flaws are not even nits, but micro-nits or even nano-nits, where they exist at all. None of them can detract from the reliability of the Gambia's evidence or the evidentiary weight to which it is entitled. For example, Myanmar complains that the FFM's reports fail to set out their methods of work. But in fact, the reports have entire sections dedicated precisely to that purpose, and they confirm that in carrying out their investigation, the mission's members and staff scrupulously employed and adhered to the best practices spelled out in the OHCHR's guidelines. Myanmar also claims that the interviews of victims and witnesses conducted by the FFM, quote, appear to have been cursory. How do they know this if they refuse to participate in the interviews? The answer is they speculate. They say, for example, quote, given the very small size of the FFM staff, it is apparent that the interviews of 875 people in that very short space of time can hardly have been in-depth, and that the process can hardly have been careful and detailed. This is pure conjecture, and it is belied by the facts. According to its 2018 report, the mission deployed to the refugee camps in Bangladesh in September 2017, immediately after the clearance operations had been conducted, and interviewed many of the newly arrived survivors who had witnessed them. Further interviews were conducted during numerous additional field missions between September 2017 and July 2018, which lasted many weeks. For the 2019 report, the mission made 6 field missions to collect evidence between February and June 2019. There is no reason to believe that the amount of time spent or the number of staff involved were inadequate to the task at hand. Again, both reports confirm that the mission's interviews were conducted in conformity with the OHCHR's best practices. Myanmar also attempts to undermine the probative value of the 2018 and 2019 reports on the further speculation that the victims and witnesses interviewed by the FFM were fearful of ARSA and subject to its influence. The FFM did not ignore this possibility. That is why, as stated in its 2018 report, it took particular care not to take the interviewees' statements at face value, but to take into account, quote, the witnesses' political and personal interests, potential biases, and past record of reliability, as well as, quote, where and how the witness obtained the information he or she was providing, and, quote, the reasons for which the witness provided the information. Myanmar offers no evidence, none, that any of the witnesses interviewed by the FFM was in fact influenced by arson. Myanmar has much less to say about the 6 IIMM reports. It argues only that they are, quote, not the best evidence of the facts stated in them because they provide, quote, second-hand descriptions of the evidence. But this cannot be a reason for distrusting the reports. All investigative reports, including those on which the court has previously relied, are necessarily second-hand accounts, since the investigators who author the report are not themselves eyewitnesses to the events that are described. What matters, as the court has explained, is their independence, the comprehensiveness of their sources, and the care they have taken in investigating and reporting the facts. Myanmar has nothing to say about any of this in respect of the IIMM's reports. Instead of attacking those reports, Myanmar criticizes the Gambia for not placing more reliance on them in our written pleadings, suggesting that our alleged omission constitutes an admission that they are not supportive of our claims. It is inexplicable, they claim, that the Gambia has not sought to base its claim on materials provided by the IIMM. Frankly, we don't know what they're talking about. First of all 6 of the IIMM's reports are very supportive of our case. In fact, we annexed 5 of these reports to our reply and quoted extensively from them within it. The only one we did not address was published in September 2025, 16 months after our reply was submitted. You will hear about that one too from my colleagues. I turn next and more briefly to the evidence contained in the reports of non-governmental organizations. The Gambia has submitted 50 such reports, including from leading human rights organizations with well-earned reputations for expertise, independence, and objectivity, some of which I identified earlier in my speech. The Gambia does not rely on these reports as its principal sources of evidence, but, consistent with the court's jurisprudence, as material that corroborates and confirms the evidence contained in the 2 reports by the fact-finding mission and the 6 reports by the IIMM. The Gambia considers it impressive that these reports, more than 4 dozen of them, fully support the factual findings and the conclusions reached by the 2 United Nations bodies. Myanmar cannot credibly object to giving them evidentiary weight because it too has offered into evidence certain NGO reports, including from 2 of the same sources relied on by the Gambia, Amnesty International and the International Crisis Group. Myanmar relies on their reports to support its narrative on ARSA. We, of course, do not object to their reliance on these reports, although we read them differently. In fact, we ourselves have called attention to the following passage from the Amnesty International report that Myanmar submitted as Annex 268 to its counter memorial. Myanmar's security forces, and in particular the military, responded to the attacks and subsequent clashes with an unlawful and grossly disproportionate campaign of violence marked by killings, rape, and other sexual violence, torture, village burning, forced starvation tactics, and other human rights violations and crimes under international law, all of which has been well documented by Amnesty International and others. The military's attacks, which targeted the entire Rohingya population living in northern Rakhine State, have been both widespread and systematic. Nothing can justify such violations. This, I emphasize, is from their evidence. I come next and last to the probative values. The probative value of the witness statements that have been submitted. There should be no debate about the value of the witness statements obtained by the IIMM, which it shared with both parties. As I pointed out earlier, there were 41 such testimonies, of which the Gambia has submitted 12 and Myanmar has introduced 18. The IIMM redacted the names of these witnesses for their protection. Nevertheless, both parties rely on them, thereby waiving any objection they might have to the court's reliance on witness statements that have been redacted in this manner and for this purpose. As previously noted, the Gambia has also submitted another 48 signed witness statements, 34 in unredacted form, and 14 with the names and other identifying information redacted at the request of the witnesses for their own protection. Notably, none of the statements from Rohingya victims or witnesses were obtained by the Gambia. All were obtained by non-parties to these proceedings. 44 of the statements obtained by the Gambia were obtained by 44 of the statements submitted by the Gambia were obtained by an independent organization, Legal Action Worldwide, which relied on a team of senior criminal investigators, including members of the Royal Canadian Mounted Police. The The Gambia submits that these statements, which further corroborate the findings of the UN fact-finding mission and the IIMM, have significant probative value and are entitled to evidentiary weight. As the court said in Croatia, quote, although some of these statements were made several years after the events in question, they are by victims or eyewitnesses of acts of ill treatment, torture, and rape. The court gives evidential weight to these statements. Despite this, Myanmar objects to them. It objects to all of the witness statements where the names have been redacted, except, of course, for those on which Myanmar itself relies. In this regard, we refer again to what the court said about unsigned statements in Croatia. Quote, the absence of signatures of the persons who made the statements or took them does not in principle exclude these documents. However, the court has to ensure that documents which purport to contain the statements of individuals who are not called to give oral testimony faithfully record the evidence actually given by those individuals. That assurance exists here because the statements are in fact signed by the witnesses, with the signatures, with some of the signatures subsequently redacted and vouched for by the entities that took the statements. Myanmar objects in particular to the statements obtained by the Royal Canadian Mounted Police on the ground that Canada is biased against Myanmar due to its intervention in these proceedings, and the RCMP must therefore be regarded as partisan rather than neutral. According to Myanmar, this requires that the statements it obtained be disregarded by the court because, quote, Canada overtly sides with the Gambia against Myanmar. This is a rather broad definition of partisan, too broad in our estimation. But if witness statements obtained by a party or an intervener are to be disregarded, then the 28 witness statements obtained by Myanmar itself for the purposes of this case and submitted as annexes to its counter-memorial and rejoinder would certainly fall into that category. As the court said in Bosnia, quote, it will treat with caution evidentiary materials specially prepared for this case and also materials emanating from a single source. In Croatia, the court declined to give evidential weight to statements obtained by the Croatian police, where, quote, the words used appear to be those of the police officers themselves. Are written statements given under the watchful eye of the Tatmadaw any more reliable? The question answers itself. In contrast to the witness statements obtained by Myanmar, as I have indicated, none of the statements submitted by the Gambia were obtained by the Gambia itself. Mr. President, members of the court, I have given you the reasons why we believe you should consider the Gambia's evidence to be reliable and to merit great evidentiary weight. I trust that this will be of assistance to you as you hear and consider that evidence in the course of these proceedings, commencing with the next speaker. I thank you again for your kind courtesy and patient attention, especially for the second time in the same day, and I ask that you please call my esteemed colleague, Ms. Pasipanoja, to the podium, unless, Mr. President, you believe it would be appropriate to take the afternoon break at this time.
I thank Mr. Reckler for his statement. I now invite Ms. Pasipanoja to address the court. You have